Good morning, everyone. Thank you very much for coming. We'll have a hearing today. Abortion until birth, the need to pass the Pain-Capable Unborn Child Protection Act. I've introduced legislation with many of my colleagues on this committee on the Republican side. It's called the Pain-Capable Unborn Child Protection Act. It would provide common sense protections for unborn children at 20 weeks after fertilization, a point at which there is significant scientific evidence that abortion inflicts tremendous pain on the unborn child. There are only 7 countries in the world that allow wholesale abortions at the 20-week period. They include China and North Korea. I think Iran, too. The United States should not be in this club. I don't believe abortion 5 months into the pregnancy makes us a better nation. America's at her best when she's standing up for the least among us. We know that an unborn child at the 20th week of pregnancy can feel pain. In fact, anesthesia is administered directly to the unborn child in second trimester fetal surgery. I want to repeat that again. It's standard medical practice to provide anesthesia to a child at the 20-week period because we know they feel pain. So we're providing anesthesia to save the baby's life through an operation. We don't want to do it in a painful way. That's why we provide anesthesia. That says a lot, I think, about the development of the unborn child. This is a new legal theory. Under Roe v. Wade and Planned Parenthood versus Casey, abortions now are allowed until until fetal viability. After that, the state has an interest. What we're saying here is that if medical science tells us that the baby is well developed at 5 months, can feel pain, developed enough to feel excruciating pain, and a procedure to save the baby's life, then we should have restrictions on abortion. You can only imagine the pain that comes from dismemberment. So the point is that legislative bodies like the Congress should have the authority to protect an unborn child from excruciating pain. And that is the theory of the case. And I believe that this is a reasoned approach to a difficult problem. There's probably a reason that only 7 countries in the world allow on-demand abortions at 20 weeks. When you understand what's going on, it's not exactly where you want to go. And I'm trying to have a hearing so that we all understand what's going on. We make an intelligent decision as a nation. Do we want to stay in this club or not? As to me, I do not. And I think that's going to be a widely held view in America when Americans understand what we're trying to do here. The bill focuses on the abortion provider, not the mother. There can be no prosecution of the woman. The penalties will lie against the abortionist. And it is a simple concept. At 5 months, abortion on demand will stop. You will have exceptions for the life of the mother and pregnancies that occurred from rape and incest, commonly held exceptions. So I look forward to this hearing. I look forward to a debate. These are emotional issues, but the country needs to come to grips with the reality of 2019. In 2019, because of the advancement of a medical science, we know that an unborn child in the 5th month of the birthing process can recognize sounds, has 10 fingers and 10 toes, can stretch, can yawn, and can feel pain. And it's up to people in legislative bodies to come to their aid and prevent an excruciating death and have exceptions that make sense. That's what this hearing is all about. With that, I'll turn it over to Senator Feinstein.
Thank you very much, Mr. Chairman. I'm really concerned that this committee is spending time on legislation to limit access to reproductive health care, legislation that has failed to pass the Senate on more than one occasion and will not move in this Congress as well. In addition, it's unnecessary and divisive. It divides members on this committee and is focused on overturning the constitutional rights of women. Let me take the subject of pain, and let me begin by quoting the American College of Obstetricians and Gynecologists. This is the premier professional organization. Here are the scientific facts concerning fetal pain. A human fetus does not have the capacity to experience pain until after viability. Rigorous scientific studies have found that the connections necessary to transmit signals from peripheral sensory nerves to the brain, as well as the brain structures necessary to process those signals, do not develop until at least 24 weeks of gestation. Because it lacks these connections and structures, the fetus does not even have the physiological capacity to perceive pain until at least 24 weeks of gestation. I could go on, but I'd ask that this statement from the American College of Obstetricians and Gynecologists be entered into the record.
Without objection.
In 2019, women are more than half of the population. We run Fortune 500 companies. We're leaders in federal, state, and local governments across the country. We're heads of households. Yet we're still fighting against efforts to substitute the judgment of politicians in making the most personal, private, and difficult decisions we may face as a woman in our lifetime. No man faces the kind of criticism and second guessing of this behavior and medical choices as do women. We are continuing to fight against efforts to restrict our right to make our own health care decisions. I remember what it was like before the courts recognized women had the constitutional right to make their own reproductive health care decisions. We cannot return to those times. I remember them well. I actually served on a term-setting and paroling authority appointed by the governor of the state of California in the 1960s, and I sentenced women convicted of abortion and also granted them parole dates. It was one of the most painful things I did, and the stories I heard, I will never, ever forget. The legislation being discussed today would ban abortion at 20 weeks and threaten doctors with prison. Unfortunately, too often, politicians promoting legislation like this have very little experience with women's reproductive health care and know very little about what happens when women get pregnant. Today, we're going to hear from two witnesses, both mothers, both wanted to get pregnant, both were excited to have their babies, but unfortunately, both faced extremely difficult tragedy. One of the witnesses today learned that her baby had a fetal abnormality that would not allow him to live outside the womb. Mr. Chairman, these stories are not unique. In fact, women who end up having an abortion later in their pregnancies are often facing an excruciating, difficult, and painful reality that they have their baby or have a significant medical trauma. I have met with countless women, largely because of what I did in the area of criminal justice, who have come in to tell me their stories and cried recalling their heart-wrenching experiences, finding out that their baby would not live or they had a miscarriage that had not completed. One woman I met with told me how she had a miscarriage that was not complete, and the local hospital would not perform the abortion needed to ensure she did not get an infection. These are the most personal, the most difficult decision any woman can face. It's absurd to pass laws that substitute the judgment of politicians who are not in the doctor's office, who do not know the details of each case, who are in no position to judge what the outcome should be. These decisions should be made by the woman with the advice of her doctor. But even if we can't agree on who should make these personal medical decisions, we already know that the legislation is unconstitutional under Roe v. Wade and Casey v. Planned Parenthood. more than 20 states have enacted laws that ban abortion at 20 weeks. North Carolina, Arizona, and Idaho each enacted 20-week bans that were struck down as unconstitutional by federal courts. In fact, the Supreme Court refused to review the circuit court's decision. So why are we doing this? There's no reason a nationwide 20-week ban would fare differently. The Supreme Court has made clear repeatedly that laws banning abortion before viability are unconstitutional. So why are we doing this? I believe the only reason is politics. It's also important, though, to note that this bill creates new hurdles for women who have been victims of rape or incest. Rape victims would no longer be able to access reproductive care unless they could prove they received medical treatment or counseling for the rape or reported the assault to law enforcement. This is really shocking. Think of a young girl who's a victim of sex trafficking. She's repeatedly beaten and raped, and this isn't only in small numbers, it's in very big numbers in this country. She's locked up at night so she can't escape. Eventually she gets pregnant. Even though she has no ability to get help or escape her situation, this bill would deny her right to access an abortion because she failed to secure help from law enforcement or a government official. And yes, this does happen. These girls don't have control over their own bodies. They have no freedom to deny medical care to rape and incest victims because they don't have the right paperwork, didn't get the right kind of counseling, or have not reported their assault to law enforcement is just unworkable. It's also cruel. There's no doubt that this hearing is part of an ongoing political effort to undermine women's ability to access health care and control their own bodies. Once again, last year, 16 states enacted 44 new restrictions on women's access to comprehensive reproductive health care. In addition, these restrictions are growing more extreme. Georgia recently became the third state this year to pass a law banning abortion at 6 weeks. 6 weeks. At 6 weeks, many women are just discovering they're pregnant, and some women may not know at all. A law banning abortion at 6 weeks is nothing more than an attempt to overturn Roe v. Wade. There have also been repeated attacks on women's reproductive rights by the Trump administration. Last month, the Trump administration issued new Title X rules attempting to defund Planned Parenthood. And over the last 2 years, the administration has restricted women's access to birth control, denied reproductive care to pregnant women and girls in government custody, promoted legislation to dismantle the Affordable Care Act and its protections for women's health, and challenged women's rights in court. So I want to be clear. Today's debate is not about passing legislation to improve medical care. It's about advancing an ideological agenda. The Constitution guarantees our right to privacy and our right to access reproductive health care, and there are a whole line of cases that back it up. While many of my Republican colleagues remain determined to turn back the clock and drag our country back to pre-Roe v. Wade days, that is just not going to happen. And as long as I'm on this committee, I'll not let it happen. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. We have one panel today. Ms. Melissa Oden, founder of the Abortion Survivors Network from Gladstone, Missouri. Dr. Valerie Peterson, PhD, Director of Partnership Development, Equal Opportunity School, Dallas, Texas. Thank you. Dr. Donna Harrison, MD, Executive Director, American Association of Pro-Life OBGYN Physicians, Eau Claire, Michigan, the Honorable Jen Jordan, State Senator, Georgia's 6th District from Atlanta. Thank you. Ms. Catherine Glenn Forrester, President, CEO, Americans United for Life. Thank you all for coming, and Ms. Oden, you can start.
Chairman Graham and members of the committee, thank you for this hearing, Abortion Until Birth, the Need to Pass the Pain-Capable Child Protection Act. Experts here today will be providing you with the research regarding unborn children experiencing pain. Today, I will be providing you with my insight into my experience of surviving an abortion, and in the words of doctors, being subjected to excruciating pain in the process. In August of 1977, my biological mother, as a 19-year-old college student, had a saline infusion abortion forced upon her against her will by her own mother, who was a prominent nurse in their community of Sioux City, Iowa. It was my grandmother's close working relationship with the local abortionist, Dr. Kelberg, that enabled them to force it upon her against her will. It's estimated that she was likely about 31 weeks pregnant with me at the time of that forced abortion. As a toxic salt solution of that saline infusion abortion was injected into the amniotic fluid surrounding me in the womb, attempting to scald and poison me to death, I wonder how long it took for that pain to set in. If you read about it online or in medical journals, you'll find that children like me are actually called the red-skinned or candy apple babies because that toxic salt solution would turn the skin bright red as it peeled it away and moved internally into the organs. I wonder how much I thrashed about in the womb as it attacked my body. I've met many women who had saline infusion abortions and who have told me that they actually felt their child thrashing about in their womb after the delivery of that toxic salt solution as it started to poison them. I can only imagine how much pain I was in over the course of the next 5 days as I soaked in that toxic salt solution as they tried time and time again to induce my birth mother's labor with me. I can only imagine how much pain I was in when I was finally expelled from the womb on the 5th day of that abortion procedure. My arrival into this world was not so much birth, but an accident, a live birth after a saline infusion abortion. My medical records actually state a saline infusion for an abortion was done, but was unsuccessful. I've included this record for you to review today, along with another that identifies a complication of pregnancy as a saline infusion. I can only imagine how much pain I was in when I was laid aside that day, in the words of a nurse who I've now been connected with, and who was brave enough to share those details of my life story with me, as arguments about my life and whether I would be provided medical care or simply left to die, like my grandmother instructed the nurses to do, ensued that day. I can only imagine how much pain I was in when a nurse courageously rushed me off to the NICU, shouting out, she just kept gasping for breath, and so I couldn't just leave her there to die. This was also reported to me from the nurse who received me there in the NICU that day. I can only imagine how my pain finally began to subside as medical treatment was provided to me. Sadly, my medical records state that the doctors initially suspected I had a fatal heart defect because of the amount of distress I presented with. I suffered from severe respiratory problems, jaundice, and seizures. I weighed in at 2 pounds, 14 ounces, which is what led a neonatologist to remark in my medical records that I was approximately 31 weeks gestation, as opposed to the 18 to 20 weeks that the abortionist had indicated. My health grew steadier by the day, not simply because of the medical care that I received, but because of the love that I was given. I've been blessed to be connected with a number of nurses and even a volunteer who held me, gave me a name when I was left nameless for 2 months in the hospital, who prayed over me, even knitted me baby booties that I still have in my possession today. I was even more blessed to be loved wholeheartedly by my adoptive parents, who weren't deterred by the doctor's prognoses that I would likely suffer from multiple disabilities as a result of surviving that abortion. My life has been a set of many miracles, which includes being the mother of 2 daughters, and now being united with my biological mother and many members of both her family and my biological father's. I've lived every day since discovering the truth about my survival at the age of 14, knowing that sadly, children like me are subjected to similar horrific, painful abortion procedures that lead to their death. Abortion doesn't spare a child from suffering. It causes suffering. We live in a day and time where the science of human development, the power of ultrasound, and the sheer number of survivors like me clearly shows the truth about life. I know of 282 other survivors just like me through my work with the Abortion Survivors Network, although statistics reflect that the actual number is much higher. There should no longer be a question of when life begins. There should no longer be the question of which lives, if any, should be protected. There should be no question of whether there should be limits to abortion. We are one of the few nations who fail to do so, and the American public continues to report through polling that they support such limits. There should be no question that every child should be spared from the excruciating pain of an abortion procedure like I was subjected to. The question that does remain, however, is what you will do in the face of this reality about life and abortion in our nation. I'm here today to ask you, will you commit to preventing what happened to me from happening to other children? Every child deserves better than to suffer the pain of an abortion. Thank you for your time and attention this morning.
Thank you. Dr. Peterson.
Good morning, Mr. Chairman and Ranking Member Feinstein and members of the committee. My name is Valerie Peterson. I am honored to be here today from Dallas, Texas, to speak on behalf of women who will need an abortion later in pregnancy. I worry about their health and safety if a law is passed that would ban abortion after 20 weeks. I'd like to briefly tell you about my background. I grew up on the south side of Chicago in the Roseland community, which is known for its violence, gangs, and drug activity. My parents worked hard to care for my brother, sister, and me. As a junior in high school, I became pregnant and had a beautiful baby girl. One teacher said I should drop out of school and give up my dream of going to college. But with the help of my English teacher and my own determination to succeed, I finished high school and enrolled in college away from home. I finished high school and then went to college, and during my sophomore year, I gave birth to a second daughter. Going to college full-time, caring for my 2 young daughters, and working full-time was tough, but I kept going. Now I have a doctoral degree in education. In 2015, when I got the news that I was pregnant, I was excited and shocked because several doctors had told me that I couldn't have any more children. I was thrilled to be pregnant, and I did everything I needed to make sure I had a healthy pregnancy. A maternal fetal medicine specialist took over my care because I had high blood pressure and my pregnancy was considered high risk. This meant I had frequent office checkups and a series of ultrasounds that was given earlier than standard. 16 weeks into the pregnancy, I received shattering news. My son had lobar holoprosencephaly, which means that his brain was not developing properly. The doctor showed me my baby's ultrasound and explained that his brain was full of fluid. There was a hole between his brain and spinal cord, and there was no separation between the left and right hemisphere. My doctor gave me 2 options: either carry the pregnancy to term, which would most likely end in miscarriage or the delivery of a stillborn baby, or terminate the pregnancy. The diagnosis and these 2 terrible options broke my heart. But once I saw the pictures of my son's brain, I knew that continuing to carry this pregnancy would be emotionally and physically traumatic. And not just for me, but also for my 2 daughters who were excited about having another sibling. I made the devastating decision to terminate the pregnancy. In my journal entry, which I have with me today, before the abortion, I wrote this to my son. I decided to name you Ethan because Ethan means strong. I am blessed that you were able to come into my life. Now I'm giving you back to God. Please know that I will always love you and you will forever be in my heart. I am grateful that I was able to get the care I needed, but I worry about all the women who, under this bill, would be denied the care they need. Women seek abortions later in pregnancy for a broad range of reasons. Mine is my own, and I know it because I lived it. But I believe that no one else can know what was best for my family and me, or for any other woman. I know that Ethan came into my life for a reason. It is why I am sitting here at this hearing sharing my story with the committee and with the world. Before my personal experience, I had never been involved in activism. I never had an opinion on abortion before I needed one myself. Now I care deeply about this issue, and at this critical moment, when so much is on the line for women and their families, I feel compelled to speak out. If the bill you are considering, S-160, were to pass and ban abortions after 20 weeks, women will be prevented from getting the critical health care they need. This committee must consider the harmful impact this bill would have on the health and well-being of so many women and their family, just as it had an impact on mine. I urge this committee to reject Bill S-160 and stop efforts to restrict or ban abortion. Thank you for giving me this opportunity to speak with you today.
Thank you, Dr. Harrison.
Thank you, Chairman Graham and members of the Senate Judiciary. The most vulnerable people group in the United States are unborn children in the womb. I'm Dr. Donna Harrison, a board-certified obstetrician and gynecologist, and the executive director of the American Association of Pro-Life Obstetricians and Gynecologists. I submit this testimony on behalf of our membership of over 4,000 reproductive health medical professionals across the United States. There are small human beings in the womb who are being pulled apart in pieces or having their skin burned off or partially delivered through their mother's vagina and having their brains pierced and sucked out through a suction catheter. The Pain-Capable Unborn Child Protection Act will protect unborn children in the United States from being killed in these brutal ways. Many of the children being protected are children old enough to survive outside their mother's womb. The fact that unborn children who are 20 weeks or older can live outside the womb underlines the fact that these tiny human beings are separate individuals, and we as a nation have both a right and a duty to protect our most vulnerable members from being hurt or killed. It is scientific fact that 20-week babies are very sensitive to pain. They react the same way that you do. They withdraw from painful stimuli. They release stress hormones. Their heart rate increases, and their breathing increases. These are measurable changes under pain. The structures which transmit painful stimuli from the skin to the brain are present very early in fetal life. And anesthesiologists for the last decade have used fetal anesthesia as standard of care for in utero fetal surgery. When an unborn human being has to undergo surgery in the womb, the anesthesiologist gives that tiny human being separate anesthesia. Why? Because the anesthesia given to the mother is not sufficient for pain relief in the fetus. It is standard of medical care to give the fetus separate anesthesia when surgery is performed, and it is pure pro-abortion fantasy to claim that pain relief given to the mother causes the fetus not to feel pain. Fetuses feel pain just like you do, and their body reacts to pain just like you do. Appendix A of my testimony is Aplag Practice Bulletin 2, Fetal Pain, which is a summary of the scientific literature on fetal pain up to 2018. Appendix B is the testimony of embryologist Dr. Maureen Kondik before the U.S. Judiciary Committee regarding the capacity of unborn human beings to feel pain. Does an abortion in the second and third trimester cause fetal pain? The answer to this question is obvious when you look at the reality of what is done to these unborn human beings during an abortion. This reality is disturbing to hear, but it's even more disturbing the fact that these procedures are done every day. Abortions done at or after 20 weeks are done by one of three procedures: dismemberment abortion, which is a D&E, and I attached Appendix C, partial birth abortion, which is Appendix D, or 3, induction, which is saline or prostaglandin induction, which is Appendix E, a saline abortion, a saline induction. The most common method by far is D&E. I would invite you to go to abortionprocedures.com, narrated by APLOG board member Dr. Anthony Levatino, who has performed thousands of abortions. In a D&E abortion, the mother's womb is forced widely open to allow a grasping instrument to be inserted in the womb. The living baby is pulled apart in pieces, an arm here, a leg there, maybe 10 to 15 pieces to get all the baby's body out. These babies were alive when the D&E was started. Dr. Warren Hearn, a Colorado abortionist who has performed numerous D&E procedures, wrote a textbook on abortion which states this: "There is no possibility of the denial of an act of destruction by the operator of a D&E abortion. It is before one's eyes. The sensations of dismemberment flow through the forceps like an electric current. It is hard to imagine a more gruesome way to die. If veterinarians ripped apart living dogs or cats to kill them in the same way that living human unborn children are ripped apart in the D&E procedure, the outcry would be deafening. But what is worse is there is zero, zilch, nada, no medical reason to perform an abortion to separate the unborn child from the mother. There is no medical reason to perform an elective abortion after 20 weeks, the time when the fetus is capable of surviving outside of his or her mother's womb, in order to end a pregnancy. The unborn child could be separated from the mother by delivery, resulting in a live birth by C-section, or by inducing labor, with the dignity inherent in the birth process for that unborn child, and safer for the mother than the D&E used in elective abortion. It is clear from testimony by abortion practitioners during the U.S. Supreme Court partial birth abortion ban that the purpose of an elective abortion is to produce a dead baby, not to separate the mother and the fetus in an emergency. Thank you.
Senator Jordan.
Chairman Graham, Ranking Member Feinstein, and distinguished members of the committee. My name is Jen Jordan, and I currently serve as a Georgia State Senator. I was invited to come before you today to speak to the 20-week abortion ban before this committee, specifically because my home state of Georgia has had a similar ban in place for 7 years and has now acted to effectively ban all abortion at 6 weeks. There are real-life implications to these bans. Since its passage in 2012, Georgia's 20-week ban has had a profound and deadly effect on the women in this state. Currently, it is difficult to get an abortion in Georgia, but it is just as difficult to give birth, and exceedingly more dangerous. This is especially true if you are poor and live in the rural areas of Georgia. 50% of Georgia counties do not have a single OBGYN. 17 rural hospitals have closed in the last 7 years. Only 59 of Georgia's 159 counties even have a labor and delivery unit. The criminalization of doctors who provide basic reproductive care and treatment required by the medical standard of care has been profound. Since the passage of Georgia's 20-week ban, we have seen the maternal mortality rate double, if not triple, in the state of Georgia. This is no coincidence. And although the state of Georgia ranks 50 out of 50 states for maternal mortality, it hasn't sought to expand access to health care to poor women in rural areas, and in fact, it has now acted to do the opposite. Just over a week ago, the Georgia General Assembly passed a 6-week abortion ban. The new law, currently awaiting signature from the governor, will effectively ban all abortions at a point in time before a woman even knows that she is pregnant. 6 weeks pregnant means that maybe the woman is about 1 to 2 weeks late after an expected menstrual period. This assuming she is not one of the many women who have irregular cycles. But the law doesn't stop there. In addition to subjecting physicians to criminal prosecution and imprisonment, the 6-week ban will now also make women criminals for seeking basic reproductive care by subjecting them to prosecution and imprisonment for up to 10 years if they terminate a pregnancy even at its earliest stages. Any woman who suffers a miscarriage would be subject to scrutiny. She would be at risk of a criminal indictment for virtually any perceived self-destructive behavior during pregnancy, which could cause miscarriage, including smoking, drinking, even using legal medications. Women could even be prosecuted for miscarriages caused by the failure to act, such as a failure to secure adequate prenatal medical care. This is chilling, and let me tell you why. Because every woman has a story. every single one of them. Most never say anything because of the effect that it has on their souls. But these stories are powerful because they are the reality of women's lives every single day, and I am no different. The deepest, darkest times of my life have occurred in the presence of and with my physician. You see, I've been pregnant 10 times. I've seen what many call a heartbeat 10 times, but I've only given birth twice. I've lost 7 pregnancies in varying points of time before 20 weeks and 1 after 5 months. I have laid on the cold examination table while a doctor desperately looked for any sign of life. I have been escorted out the back door of my physician's office so as not to upset the other pregnant women in the waiting area. My grief on full display and uncontainable. And I've been on my knees time after time in prayer to my God about my losses. And I have loved each and every single one of those potential lives, and I have grieved each passing. But no matter my faith, my beliefs, my losses, I have never, ever strayed from the basic principle that each woman must be able to make her own decisions in consultation with her God and her family. It is not for the government to insert itself in the most personal, private, and wrenching decisions that women make every single day. My experience wasn't about abortion, but I believe it's what's at stake here. It's about the fundamental right to privacy of women. Matters such as a woman's ability to choose to start a family or to terminate a pregnancy involve the most intimate and personal decisions a person can make. We all know that a federal 20-week ban on abortion contravenes long-established constitutional parameters with respect to the fundamental right of privacy. But even beyond that, states like Georgia have already served as test cases for the effects of these unconstitutional bans. The women in my state have already suffered the consequences that I pray the rest of the women of this country won't have to bear. Thank you.
Ms. Foster.
Mr. Chairman, Ranking Member Feinstein, and members of the committee. My name is Catherine Glenn Foster. I serve as President and CEO of Americans United for Life, America's oldest and most active pro-life legal advocacy organization. The Pain-Capable Unborn Child Protection Act would protect the lives of unborn children who feel pain in late-term abortions, as well as the women who carry them, except when necessary to protect the life or physical health of the mother, a significant minority of late-term abortions. The Pain-Capable Act is based upon the nation's interest in protecting the lives of unborn children from the stage at which substantial medical evidence indicates that they are capable of feeling pain. It restricts some but not all abortions after 20 weeks post-fertilization age, 22 weeks post-LMP, last menstrual period, or gestational age. Although later-term abortions account for a significant number of abortions, only about 15,600 annually occur after 20 weeks, or 1.5% of all abortions. 21 states have enacted similar prohibitions on abortion after 20 weeks, and 18 of those measures are still in lawful effect. Only 3 of the 21 states define the 20-week limit as beginning at 20 weeks LMP, 2 weeks earlier than the pain-capable bill. None of the 20-week post-fertilization laws that rely on fetal pain, like this act, have been challenged outside of the Ninth Circuit, and that is striking, especially in light of the current wave of ongoing litigation over state abortion regulations. We believe that the reason is simple. Abortion advocates know that these measures are likely to withstand scrutiny by the Supreme Court. The late-term abortion restriction contemplated by this act falls well within existing Supreme Court abortion jurisprudence. The notion indulged by a small number of courts reviewing 20-week limits that abortion regulations that operate prior to viability are per se unconstitutional is fallacious. In Gonzalez v. Carhart, the court upheld a prohibition on partial birth abortion that operated throughout pregnancy, pre as well as post-viability, in deference to Congress's legislative findings that the prohibition protected against fetal pain and upheld the integrity of the medical profession by drawing a bright line between abortion and infanticide. Changes in the public's factual understanding may better inform the court's perception of governmental interests as well. One such change of fact in Gonzalez was the gruesomeness of the partial birth abortion procedure. Crediting Congress's policy judgment that the practice of performing a partial birth abortion is a gruesome and inhumane procedure, the court upheld a complete ban on partial birth abortions except where necessary to save the life of the mother. Gonzalez then establishes that factors other than viability matter to the court's abortion jurisprudence. Responding to current medical understanding, this act proposes limitations on abortions after the 20-week mark in order to protect against fetal pain and a significantly increased risk to maternal health. These are the very kinds of state interests based on evolving medical evidence that are not captured by the viability line, but that the court recognized in Gonzalez. Medical information on fetal neurological development and a child's consequent ability to feel pain in the womb is a concern of women considering abortion, and providing this information is relevant for a woman to make a fully informed choice on whether or not to obtain an abortion. Insofar as the existence of pain in the preborn infant at or before 20 weeks is firmly established in the congressional findings of S-160 and reflects a reasonable reliance by Congress on current medical science, protecting infants in the womb from the intense pain felt by an abortion during an abortion is an appropriate and constitutional state interest in restricting abortion beyond this time frame. As the Supreme Court said in Gonzalez, the state has given state and federal legislatures wide discretion to pass legislation in areas where there is medical and scientific uncertainty. The Pain Capable Act also protects women from the serious risks of late-term abortion. In 1973, the Supreme Court enshrined abortion as a constitutional right without any real consideration of the impact of abortion on maternal health. No medical data was entered into the legal record, yet Roe rested in part on the medical assumption that abortion is safer than childbirth. In fact, when Roe was decided nearly 5 decades ago, there were few, if any, peer-reviewed studies related to the risks of abortion. We now know that the risk of harm increases substantially with gestational age. It's the strongest risk factor for abortion-related mortality, and the incidence of major complications is significantly higher after 20 weeks gestation. A woman seeking an abortion at 20 weeks is 35 times more likely to die from the abortion than she was during the first trimester, and at 21 weeks or more, she is 91 times more likely to die from the abortion. Further, researchers have concluded that it may not be possible to reduce the risk of death in later-term abortions because of the inherently greater technical complexity of later abortions. Therefore, even if we set aside the debate over whether abortion at early gestational ages is relatively safe, its risks at 20 weeks and beyond put the lie to Roe's assumptions that access to the procedure must be guaranteed for virtually any reason. Today, I strongly urge this committee to protect maternal health in preborn children who feel pain and pass S-160. It is constitutionally sound and will protect women from the harms inherent in later-term abortions, including the increased risk of death. It will also respect the humanity and lives of preborn children capable of feeling pain. Thank you.
Thank you all very much. Dr. Harrison, you mentioned in your testimony that it was the standard of care among anesthesiologists to administer anesthesia to the child separately from the mother at 20 weeks. Is that what you said?
It's correct. The considerations for fetal anesthesia are not the maternal indications. It's different indications, it's different dosing. That's correct.
So that's the standard of care in America today?
That is correct. And I believe I have a statement from the American Society of Anesthesiologists included in my testimony.
Well, I want the committee to understand that. There is no doubt.
No.
Have you ever
there's
known of an operation, a fetal surgery, at 20 weeks without anesthesia for the child?
no.
Could you be sued for malpractice? Never mind. Austria has limits on abortion on demand at 12 weeks, France 12 weeks, Germany 12 weeks, Spain 12 weeks. So in the 5th month, Ms. Foster, the legal theory here is that there's a compelling state interest to prevent a child from dying from excruciating pain from an abortion in the 5th month. Is that correct?
That's correct, as well as to protect maternal health.
Okay. That's different than the viability standard.
Yes.
Okay. So those states who've enacted laws like this, there has not been a challenge outside the Ninth Circuit. Is that correct?
That's correct.
Okay. Ms. Jordan, do you support limits on abortion anytime in any way during the birthing process?
Yes. I mean, you know,
What
and
would those be?
I think they're the ones that are outlined by the Supreme Court of the United States
Okay.
with respect to that. I mean,
do you support late term? You support the decision? You agree with the decision about late term abortions?
I agree with what the United States Supreme Court has laid out.
Okay, thank you. Ms. Peterson, your testimony is very compelling. I really appreciate you coming here today and sharing your life story. Dr. Harrison, as we try to fashion laws about abortion when and where, how much consideration has historically been given to the child in terms of pain in this country, feeling pain?
Very little. And
How about none until now? This great
None.
country called America has pretty much ignored this subject matter until now. Is that correct?
yes, that's correct.
Now we're talking about it. Is that correct?
That's correct.
Ms. Foster, now we're trying to act on it, right?
Absolutely, yes.
And we're one of 7 nations in the entire world that allow abortion on demand at 20 weeks. Is that correct?
That's correct.
Thank you very much, Senator Feinstein.
Senator Jordan, if I may, your state, Georgia, already has a ban on abortions after 20 weeks. According to the American College of Obstetricians and Gynecologists, often severe fetal anomalies are not even diagnosed before 20 weeks, but come only later in pregnancy. How has the 20-week ban impacted women in your state?
Well, with respect to that, I mean, there is one exception under the 20-week ban that is not mirrored in the bill before the Senate, and that deals with medical futility, which is defined under Georgia law specifically as a child having some kind of chromosomal or congenital abnormality that would result in the child not being able to really sustain life after birth. So you kind of, you break it up with respect to what you're dealing with there. I will say that we heard testimony, wrenching testimony from mothers who just happened to get a scan a little bit earlier, and they felt like they were rushed into a decision with respect to whether or not to terminate the pregnancy, that they didn't have time to really evaluate all the options because of the 20-week ban and not being able to see other healthcare providers.
I'm not understanding. Does this come before the 20 weeks or after the 20 weeks?
In terms of medical futility,
Yes.
there is no ban in Georgia on abortion with respect to medically futile pregnancies.
Say that again, medically what?
They're called medically futile pregnancies. Basically, that a child has some kind of abnormality that once they are born, they will not be able to live outside of the uterus, outside of the womb.
So you're saying that is an exception in
It
Georgia?
is an exception in Georgia.
Thank you, I did not know that. So after a woman learned, if it's after 20 weeks, if she learns she's pregnant, and there is a fetal abnormality, she can access an abortion?
She can, if it is of the type where the child would not be able to live outside of the womb or will live for a very short period of time. And there are specific categories of abnormalities that, physicians look to with respect to that.
I'd like to ask Dr. Peterson, in 2013, Texas enacted numerous restrictions on women's health care provisions. In 2016, the Supreme Court ruled that these restrictions were unconstitutional in Whole Women's Health v. Hellerstedt. However, by the time the court struck down the law, already half of the women's health care facilities that provided abortion in the state had closed down. You were told, as I understand it, that you would have to be on a 3 to 4 week long waiting list. Was this fairly typical in Texas? Are long waiting lists still common?
Yes, at the time that I had my abortion, there was a 3 to 4 week waiting list because of the whole woman's health situation. At this time, Texas is still not up to the number of clinics that it has had previously, so there are some instances in which women still have to wait in order to have the care that they need.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Hawley.
Thank you, Mr. Chairman, and thank you to each of the witnesses for being here today and for being willing to share your stories and your expertise on such a difficult but extremely important topic. Ms. Oden, Melissa, I want to start with you if I could. You are a fellow Missourian. Thank you so much for being here. It's always great to see a Missourian here before the committee, but particularly I want to thank you for being willing to share your story. I know it can't be easy, and you said you were 14 when you learned the truth. Would you be willing, if you are able and want to just to share a little bit about how you came to learn about your story and what that was like? I mean, I can't imagine what it's like for a 14-year-old to discover the truth of what had happened.
Thank you, Senator. I was 14 years old when I found out the story of my survival. My adoptive parents knew my story when they adopted me, as I shared in my testimony. They were told I would suffer from disabilities, but they kept it a secret because they wanted to protect me from the truth. They raised me to know that my birth mother loved me, placed me for adoption, and that's what they wanted me to know throughout my life. But when I was 14 years old, my older sister, as a high school student, faced her own unplanned pregnancy. And when our parents found out that she was not sure about what decision she would make regarding that pregnancy, they told her the story of my survival. And like any good teenage sister, she didn't keep it a secret from me. She didn't tell me everything, but she said something that had never been said before at our house. During an argument one night, she said, my biological parents wanted me. And I was thinking, wow, we're both adopted. I thought we were equally loved, right? And that's what urged me on. She said that night, wait up for mom and dad tonight and ask them to tell you the truth, and you will see. And so here I was on a cold October night, I'll never forget it, 14 years old, sat my mother down, asked her to explain to me, right, why my sister would ever say such a thing. And that night, my mom spoke words that no parent should ever have to say. She said, Missy, your biological mother had an abortion during her pregnancy with you, and you survived it. And there's no preparation for that. I work with survivors who are 14 or 41, and I can tell you that those words change your life forever.
Wow. Thank you so much for sharing that. Let me just ask you, Melissa, do you think that your experience as an abortion survivor, did the fact that, in this case, your grandmother, I think you testified, is the one who really wanted your mother to have an abortion and sort of forced it upon her, but did that diminish you and your rights in any way? The fact that your grandmother would have preferred you not live for, I'm sure, various and complicated reasons, but did that make you any less of a person or any less valuable as a person? Did it take away any of your dignity that's yours by virtue of being a woman?
And I appreciate you talking about that. I keep thinking about that. We hear all this talk about women's rights, but I beg the question, where were my rights in the womb? Where are the rights of the little girls who are going to lose their lives to abortion every single day? Where are my rights now as a woman who survived an abortion? Where are the rights of my daughters who never would have lived if that abortion would have succeeded in ending my life? I appreciate the discussion about women's rights, but I would appreciate a conversation about the lives of other women like me.
Thank you for that. You testified in your written testimony that you didn't think you would have survived if the abortion had been performed at a Planned Parenthood facility as opposed to a hospital. Can you talk more about that? Tell us why you think that's true and why in your case and in all of these cases for babies born like you, prompt treatment is absolutely vital.
I think that's another great question, Senator. I survived at a hospital because, of course, most late-term abortions take place at hospitals, not because they're trying to prepare themselves to provide care to children like me, but because of the greater risk to women's health the later in the pregnancy that abortion is occurring. So I was blessed to be born alive accidentally at that hospital and to have that nurse willing to rush me off from that room into the NICU, because I do believe if I would have been born accidentally at Planned Parenthood or another abortion clinic, they would not have done what they needed to do to get me to a place where medical care would be provided. They do not have that at their disposal there to immediately provide a child medical care. I am blessed indeed.
Do you think that abortion facilities that are separate from hospitals will adequately care for babies if they're not required to do so by law?
I know too much about other people's experiences to know that children like me aren't always immediately provided medical care. I think we try to make ourselves feel good, right? Thinking somehow a child must immediately be saved by by those professionals at clinics, but that is not the case. I mean, you can read up even on a case in 2007, I believe it was, out of Florida, where a child like me survived an abortion. I believe the birth mother was like 18 years old, called 911 herself, panicking in regards to this child. The child was breathing when they were placed in a biohazard bag where they suffocated to death. The child was then thrown on top of the building on the roof and was left there for a period of time before ultimately they were returned into the clinic and found later.
Oh, thank you very much, Ms. Odom. Thank you, Mr. Chairman.
Thank you. Senator Blumenthal's not here. Senator Hirano, I think, is next.
Thank you, Mr. Chairman. Dr. Peterson, thank you for sharing your experience. It is very important for everyone to hear the stories, the true stories of women who have faced abortion later in pregnancy as the best of all the unbearable options available. It cannot be easy to be so public about such a painful time for you. But if women like you don't speak up, my friends on the other side of the issue would leave the American people with a false impression that women have abortions later in pregnancy and that the medical professionals who care for them are monsters. It's a cruel and misleading message calculated to rile up the Trump base. So thank you for helping us counter it. And Senator Jordan, thank you. Jordan, thank you for your work in Georgia, standing up to the forces out to hurt women, because that's what all of these efforts really are. As soon as Donald Trump's Supreme Court justices were confirmed, both clearly intent on restricting or overturning Roe v. Wade, we saw states go on a binge of passing oppressive abortion laws like Georgia's. For example, during that time, Iowa passed a bill very much like Georgia's, which would prohibit women from seeking an abortion after 6 weeks of pregnancy, often even before they know they're pregnant. West Virginia enacted legislation that would prohibit the state's Medicaid program from covering abortion services for low-income residents. This is why these kinds of bills have a tremendously adverse impact on poor people, poor women, and minority women. We know this. Indiana passed an onerous new law requiring physicians to report confidential patient information to the state if a woman experienced complications from an abortion. Can you think of any other instance where a state or a law would force the release of confidential medical information outside of possibly a lawsuit? Louisiana passed a law establishing a 15-week abortion ban that includes criminal penalties for any physician who performs the procedure after that time, with only a very narrow exception to save the life of the mother. The states go as far as they can with the knowledge that the laws will be challenged in court and with the hope that with Justice Kennedy gone, they'll get what they want in the Supreme Court, especially from Justice Kavanaugh, who made his antipathy to abortion plain as day. If the people supporting these laws really care about protecting women and families, they would acknowledge that banning abortion results in more women dying, which we know from the highly regarded Turnaway study conducted at the University of California. And if they were interested in making the lives of children better, they wouldn't be trying so hard to get rid of the ACA and Medicaid. Nearly half of U.S. births are covered by Medicaid, and about 30 million children are covered by the program. Yet Medicaid is under continual assault by the Republicans. And most recently, the Trump budget proposed cutting $1.5 trillion from Medicaid. Another 2.8 million children under the age of 18 gained coverage under the ACA, and over 40% reduction in the number of uninsured. You know, for all of the strong support for bills like this, I'd like to see equally strong support for programs that support children and families who are here and now, rather than slashing the HHS budget and $250 million from preschool development grants that support states' early learning initiatives. Rather than taking away Title X, Title X funds that are so important to my constituents in Hawaii and elsewhere, not cutting funding for the Education Department by 10% and eliminating $6.7 billion in federal funding for after-school, before-school, and summer learning programs, teacher training, and professional development programs, school literacy programs, and programs that help low-income students achieve higher education. Or not supporting policies that leaves guns in the hands of future school shooters and policies that force children into cages at the border. The word hypocritical doesn't even begin to cover what is happening to women and children across our country. My thanks to you, Dr. Peterson and Senator Jordan, today once again. And I hope the supporters of bills that we're talking about today, both in the states and in Congress, turn their efforts to improving the lives of the children who are very much here already and who are so poorly served by the Trump administration and its policies. I have been fighting for abortion rights for women for decades, and the fact is, there are right-minded and good-hearted people on both sides of the abortion issue. There are certain issues like abortion where minds generally cannot be changed by facts. So we should consider the possibility that there are good people on both sides of this issue, and that the Supreme Court and Roe v. Wade made sure that a woman would have the ultimate decision about what is going on with her own body. I just don't understand why everyone can't understand and trust women to be able to make the decisions, some of the most important decisions that have to do with controlling our own bodies. I don't understand why we are continually confronted with these kinds of bills. You know, there is a saying that if you don't support abortion, don't get one, but leave everyone else to the painful decisions that they have to make along with their physicians. Thank you, Mr. Chairman.
Thank you, Senator. Senator Ernst.
Yes, thank you, Chairman Graham, for holding this hearing today. It is very important, and thanks for your leadership on the Pain-Capable Unborn Child Protection Act. I appreciate the time that our witnesses have given today as well on this very important topic. And I do believe that this has come to the forefront of America's conscience, particularly in recent months, with many of the discussions we have seen amongst the states. As many of you know, this is an issue that is very near and dear to my heart as well. And whenever I talk about this issue, I can't help but share a story that's very familiar to many of us about a very special family from my home state of Iowa. In July 2012, Micah Pickering of Newton, Iowa, was born prematurely at just 20 weeks gestational age, the very age at which the Pain-Capable Unborn Child Protection Act would prohibit abortions. Micah was only about the size of a bag of M&Ms, yet he was also a perfect, fully formed baby boy with 10 fingers and 10 toes. At only 20 weeks, the humanity of baby Micah was undeniable. And Micah's parents, as well as the wonderful doctors and nurses of the University of Iowa hospitals and clinics, dedicated themselves to Micah's survival. Today, Micah is a healthy, energetic 6-year-old boy. He is also a powerful testament to the fact that at 5 months of development, an unborn child is in every way a child capable of feeling pain and growing up to live a full and very happy life. Micah's story is not an isolated incident. Stories of babies surviving at just 5 months of development stretch back more than 3 decades and have become more and more frequent due to rapid advances in medical technology. Just a couple of weeks ago, I had the opportunity to visit the U of I hospitals, the NICU, and was able to meet a baby boy at 22 weeks gestational age, perfect in every way. Dr. Harrison, I want you, how long have you been practicing medicine?
Well, I practiced for a decade after graduating from OB-GYN residency, and then took up the full-time directorship of American Association of Pro-Life OB-GYNs.
Wonderful. And think back to your years of medical training with your medical school. What were you taught then about fetal pain or the age of fetal viability?
Technology has increased tremendously. At the time that I finished medical school and residency, it was 28 weeks, and below that it was very difficult for babies to survive. Now, babies are surviving at 20 fertilization weeks, 22 weeks gestation. And that's a significant percent. It's not 100%, but there's no 100% survival in any gestational age. But it's a significant percent if babies are cared for.
Exactly, and the technology is rapidly improving.
It's
for those
rapidly
babies'
improving.
survivability
That's exactly right.
rates. So what you were taught years ago is very different from what we're experiencing today, correct?
That's correct. And the reality is those babies, for OB-GYNs who follow the Hippocratic Oath, those babies are our patients as well. So we are here to advocate for those unborn human beings in the womb who are our patients and who are being killed in a very brutal way.
I appreciate that. And I would make that argument we hear many times over about a woman's body, but that is a separate body,
Well,
correct?
that's exactly right. So my right to control my body ends where somebody else's body begins. And where somebody else's body begins is in the womb. And I have to say a word about ACOG. ACOG, although has been quoted, ACOG has made statements that they are specifically a pro-abortion activist organization. They do not represent OB-GYNs on this issue. They've never polled their membership, and 85% of OB-GYNs do not do abortion. So ACOG is out of step with their rabid pro-abortion activism. And I just want to make that point because they're being quoted in this committee as though they are an independent, unbiased scientific opinion, and they are not, by their own admission.
Well, I appreciate your time today. Obviously, there is a lot of passion surrounding this issue. I am, of course, a pro-life member. I also believe in dignified death as well. So I know there is more to follow here. This is the hot topic of the day, but it is lives that we are talking about, and these are separate human lives. Right. I appreciate it. Thank you very much. Senator Durbin, you'll be recognized.
Thank you, Senator, and thank you to all of the witnesses who are here today. In the course of my political career, I've faced many hearings on this issue of abortion and many debates back and forth on the issue. I don't know that we will ever all come to agree when life begins, which is really at the heart of this whole consideration. Nor are we likely, could you excuse me a second? Nor are we unlikely to come to an agreement as to when the government should step in and make a decision on the future of a pregnancy or the outcome of a pregnancy. In fact, this bill, which I've been trying to read as we debated here, has an ambivalence in it, which I think reflects the fact that we're not sure. This bill, for example, on page 16, after having said in another section that a doctor who participates in an abortion after a heartbeat is found can be subject to 5 years in prison, this bill says a woman upon whom an abortion in violation of subsection A is performed or attempted may not be prosecuted. Clearly, there's a belief here that if this is a crime which can result in prison time for a doctor, that the bill specifically exempts any criminal culpability for the woman who sought the abortion. It's very hard to rationalize why there would be this different standard unless it reflects the ambivalence many of us have coming into this whole situation as to the women who are facing these decisions and how they make these decisions. This provision, which Senator Graham included in his bill, has been included in many before, so I'm not picking on him or pointing this out, other than the fact that this national debate continues. And it has continued in a fulsome fashion for some 46 years at least, since the decision in Roe versus Wade, maybe even before that, but certainly with political intensity since 1973 on the issue of abortion. We're talking about mothers and pregnancy and babies. So what has happened in the last 25 years when it comes to the issue of mothers and pregnancy and babies in the United States of America while we are engaged in this fulsome political debate? In this 25-year period of time, the U.S. is one of only 13 countries where the rates of maternal mortality are worse today than they were 25 years ago. While we debate abortion, mothers who are pregnant are dying at a rate in the United States which is unheard of around the world. Today, more than 700 women die every year from pregnancy-related complications, 70,000 others have serious near-fatal complications. What about the survival of children in this equation of mothers, pregnancy, and children? 23,000 infants in the United States die every year, often from preventable problems. The United States ranks 32nd out of 35 richest nations on earth in the deaths of infants. While we debate the issue of abortion over and over again, not that it isn't important, but backing up what Senator Rono said, what should be of critical importance to us is what we need to do, what we can do as a country so that mothers will survive pregnancies and infants will survive pregnancies. Shouldn't that be something we all agree on, even if we are in different positions when it comes to abortion? So several years back, before I was elected to Congress, I was working in the Illinois State Senate, and they came to us and said, do you know that they're selling health insurance plans in the state of Illinois that do not cover a mother or infant until 30 days after they're born? Why? Because so many infants do not survive that first 30 days. It was a cheap plan. We decided to get rid of that abomination in Illinois many years ago, and we decided as a nation to get rid of it when we passed the Affordable Care Act. You can't sell a health insurance policy in the United States of America that does that anymore, thank goodness. Shouldn't pro-life and pro-choice people both agree on that? That we ought to cover the mother and infant throughout the pregnancy and from the moment of birth? I'm looking for some common ground here. I've got to believe there is some common ground here. When it comes to Medicaid, as Senator Hirono said earlier, half of the babies born in Illinois are covered by Medicaid. Thank goodness we expand the coverage of Medicaid. But as Senator Jordan has reminded us, many states did not. Many pro-life states did not extend the coverage of Medicaid to make sure that the mother could give birth to a healthy baby. Can't we come together and agree on that? Thank you, Mr. Chairman.
Senator Lee.
Thank you, Madam Chair. I want to ask at the outset a question of, can't we walk and chew gum at the same time? Can't we protect the health of the mother and also the baby at the same time? It seems to me that as a civilization that can put human beings in space, along with satellites, and achieve all the other accomplishments that we have, ought to be able at least to establish those things as dual objectives that can exist in the same universe. Now, it's important to remember here that public opinion polling shows that policies prohibiting late-term abortions are widely supported by the American people. A recent Marist poll, in fact, shows that 80% of Americans favor limiting abortion after the first trimester. The policies contained in Senator Graham's bill and in Senator Sass's bill are not controversial, not at all, for the vast majority of Americans. The Born Alive Infants Protection Act of 2002 established that children born following a botched abortion are in fact legal persons for purposes of federal law. It passed the United States Senate at the time by unanimous consent. Not one senator voted against it. Senator Sass's bill is a logical complement to that legislation. It just sort of completes the same thought, but by saying that babies who survive abortions and after having done so are themselves legally recognized as persons by existing federal law should get the same kind of care that other babies get. Yet stunningly, 44 United States senators voted against this basic protection just in the last few weeks. Simply put, it's stunning to consider that one of our nation's two major political parties, a party that itself once said that abortion should be safe, legal, and rare, now almost uniformly opposes even minimal protections for babies outside the womb. Babies who, like Ms. Oden, have survived an attempted abortion. The governor of Virginia recently stated, to the shock and horror of countless Americans that under a proposed pro-choice law, in the context of a proposed pro-choice law, he said that if a baby survives an abortion, quote, the infant would be delivered and then a discussion would ensue between the physicians and the mother. This is an extremist position regarding abortion, one that's wildly out of step with the American people. Now, the Constitution, importantly, says absolutely nothing about abortion. And the legal traditions in place in this country routinely allowed for restrictions on this practice. The great liberal law professor, John Hart Ely, who was himself pro-choice, I would add, famously wrote that Roe versus Wade, quote, is not constitutional law and gives almost no sense of an obligation to try to be, close quote. In other words, this amounts to constitutional law by judicial fiat, no more and no less. So, Ms. Foster, I'd like to start with you. Where in the text of the Constitution does the Constitution place any significance on this distinction that we've talked about today between pre-viability and post-viability fetuses? A distinction that the Supreme Court has rested so heavily in its reasoning. Where does that come from? What text supports that in the Constitution?
Well, it's simply not in there. I would also point out, you're talking about the polling of Americans, and Americans United for Life recently partnered with YouGov, and we found that 66% even of self-described pro-choice Americans agree that when it comes to those post-viability abortions, that's something that we can all agree on. As a post-abortive woman myself, I know that what the Supreme Court said was true, that so many American women do come to regret that choice we made to terminate a life that we once carried and nurtured within our bodies. And so women need this information. Women need the information that we aren't getting from clinics, and so I would simply say that that when it comes to that distinction, both pre and post viability abortion restrictions are perfectly constitutional according to what our own U.S. Supreme Court has said.
So, in other words, this is a doctrine created by a court. Mm-hmm. That chose somewhat arbitrarily, at least arbitrarily in the sense that it's not mandated by the Constitution, that you draw a distinction based on pre- and post-viability as opposed to another factor like, say, pre- and post-pain capability. Is that right?
That's absolutely correct, and we've seen that the line change over the years through the different Supreme Court cases that the court has considered. We've seen that that standard and that line change, and as we make medical progress, as we learn more about the facts about abortion and about abortion law, we see more and more American people coming to be pro-life, to oppose, especially these brutal, barbaric third trimester and later second trimester abortions. This is really a truly bipartisan issue, except with the leadership of one of our political parties.
Thank you, Madam Chair.
Senator Klobuchar.
Thank you very much. I continue to believe, Senator Lee, that abortion should be safe, legal, and rare. And I think there's been a lot of good work that has gone on across the country in making contraception available, in education efforts, and that's why we've seen this reduction. So I want to start with you, Dr. Peterson. I want to thank you for sharing your story. I know how difficult it must have been. These are very personal decisions, and in your written testimony, you mentioned the word dignity, and the dignity that you wanted to be able to maintain to make the difficult decision you made. Can you talk about why you picked the word dignity?
Yes, because I saw tons of ultrasound scans. I had a lot of conversations with my doctor, and it was indeed a very devastating decision to make with two horrible options. But I knew that I wanted to move forward, and I knew that in order to do that, I had to make sure that everything that I did during that time was done with dignity. including the termination of my pregnancy. And so I did what I had to do in order to make myself feel that it was a dignified position that I was left in.
And you mentioned that clinics in Texas had a wait time of 3 to 4 weeks. Is that
Correct.
right?
Yes. At
And
that time.
in addition to mandated counseling and ultrasound and a waiting period, in your experience, what is the effect of these type of requirements on women when they're trying to make healthcare decisions?
I'll tell you the effect that it had on me, because it's very important and something I want this committee to realize, is that because I was 16 weeks and because there was a 3-week waiting list, 3 to 4 weeks, I was running up against the Texas 20-week ban. And because of that, I actually had to fly to another state to get the care that I needed. And I had to pay for all of that, including the procedure itself, out of pocket. So when there are women who have instances in which there are fetal anomalies or any other type of diagnosis that can come early in pregnancy, if they don't have the resources or the funds or the ability to seek health care in their communities when they need it, then they are one of the ones that becomes the person that happens after the 20 weeks because they simply could not afford the medical care to get what they needed done.
Mm-hmm. And how old are your daughters now?
I have a 22-year-old daughter and a 20-year-old daughter, and they're both in college enrolled at Kansas State University.
And how old were they when this happened?
Oh, gosh. Kennedy was 19, and I believe Devin was 17.
And how did you have to explain this to them? Do you remember that?
It was very difficult to explain once I received the diagnosis. In my journal, I kept all of my ultrasound pictures. And so using my journal and utilizing those scans was very helpful in me sharing with my daughters why I had to come to the decision that I had to come to. My youngest daughter lived through this with me, as she was home with me every single day. And so her seeing the pain that I was in and really not being able to know how to help me through that pain was, one, a learning experience for them, but also extremely difficult, and it impacted their academic studies.
Okay, thank you very much. One last question, Senator Jordan. What would it mean for women in Georgia, thank you for your service, if the barriers to women's health access were removed?
I mean, I think we've already seen what's happened. I mean, look, we passed the 20-week ban in 2012, and since then, we've lost more and more OBGYNs. I mean, we keep talking about health care and wanting healthy mothers and healthy babies, but we have to provide access to care for that to actually happen. And so when you tell physicians, OBGYNs, that's who we're talking about, that they can't provide care within the standard of care, they are not going to come to the state of Georgia. They are not going to live in the state of Georgia. They won't be licensed there. And so what we're seeing is we're seeing more and more doctors leave the state, which then results in higher maternal mortality rates and higher infant mortality rates.
Mm-hmm. Thank you very much.
Gentlelady yields back, and I'll recognize myself for 5 minutes. 4 questions. I want to begin by saying thank you to each of you for being here, for submitting your testimony, and for being so articulate in how you present your views on this. This is an area that there is wide disagreement. And it is so interesting to me, having served Senator Jordan in the State Senate in Tennessee before coming to the House and now being here in the Senate. And my hope is that we'll be able to realize that one of those first guarantees is the right to life. And it has, when I was in the House, I chaired the Select Investigative Panel looking into what was happening with big abortion and the selling of fetal tissue and body parts. We issued 15 criminal referrals from the work that we did there. And here in the House, I have the legislation that would prohibit abortion providers from getting Title X funds, which are there for women's health care. And I feel like that taxpayers want to make certain their money's not used for abortion, and they do want to make certain that their funds are used for health care for women that are in underserved communities. Dr. Harrison, I want to come to you, if I may. And Ms. Oden, thank you for your testimony and the description. She talked about the abortion procedure that she went through, which was the induction procedure. Now, there's also the dismemberment abortion and a partial birth abortion procedure, correct?
Yes, that's correct.
Would you, for the record, give a brief description of each of those so that we know what this baby in utero would be feeling when they are capable of pain?
So in the dismemberment procedure, the woman's uterus is opened by putting in seaweed, and then for the abortion, she's typically sent to a nearby hotel room and comes back the next day to see how dilated the cervix is, and more seaweed is put inside the cervix. And she's sent back to the hotel room until the cervix is opened wide enough to be able to insert the grasping instrument. So once the cervix is opened wide enough, then there's a suction catheter placed inside to remove fluid, but babies at these gestational ages don't fit through suction catheters. So the babies have to be taken out, and they're taken out by a grasping instrument called a Sofer clamp, which does not let go. So a leg is grasped, and there's a sharp pull, and the leg's removed, and then the other pieces of the baby are removed.
Okay.
So that's a D&E.
All righty. And then the partial birth abortion, if you will describe that for me.
In the partial birth abortion procedure, the baby's legs are grasped, and after the cervix is opened, the baby's legs are grasped and brought into and through the opening of the womb into the vagina, and the body is delivered to the point where the head is trapped at the opening of the cervix. And you can do that because the baby's head at that early gestational ages is much bigger than the body. At that point, a scissors or other sharp instrument is placed at the base of the brain, and the base of the brain is pierced, and a suction catheter is put inside to suck the baby's brains out. And that is done so that the skull can be decompressed, but that is also done, both of these procedures are done to make sure that the product of an abortion is produced. And that was made exquisitely clear at the partial birth abortion hearings, where the abortionist was asked in the process of birth, would they ever deliver a living baby? And they said absolutely not, because the product that they're paid to produce is a dead baby. They're not paid to do a delivery, they're paid to produce a dead baby. So it's very clear that the intent and purpose of the procedures done is not to separate the mother and the fetus, because if you wanted to separate the mother and the fetus, then Miss Oden was a successful abortion. But she was called a failed abortion because what failed was she failed to die. And that's a point that people have to understand. We separate, as OB-GYNs, we separate mothers and babies at any gestational age, but we do so with the intent to produce a living mother, and if at all possible, a living child. We never do it with the intent of producing specifically a dead baby.
My time has expired. We will ask you to submit a description of the induction procedure, even though Ms. Oden did describe that procedure well, because it is what she survived. Senator Blumenthal, you're recognized for 5 minutes.
Thanks, Madam Chair. I want to thank in particular Dr. Peterson and Senator Jordan for being here today to share your very private, personal stories and the description of your advocacy and your standing strong, millions of women like you across the country will be regarded eventually as heroes in the continuing battle to enable women to decide when they want to become pregnant and have children. And we're here in a hearing on a bill that is going nowhere. It is doomed. It is divisive. It is doomed because it will not pass the Congress. And even if it did, it would be struck down by the courts, as they have struck down similar statutes at the state level. It is divisive because it prevents us from coming to agreement on issues of health care that really impact children and women. And instead of focusing time and attention on this doomed and divisive measure, my hope is that Republican colleagues will support maternity care and treatment of pregnancy under the Affordable Care Act, that they will abandon efforts to cut Medicaid funding that in turn would handicap prenatal and postnatal health care, that they will support efforts to bolster nutrition assistance programs, such as Women, Infant, and Children, that ensures that pregnant women and their children are fed, public housing programs are provided with the assistance they need, constructive measures that really have a positive impact on health care. The fact is that these kinds of restrictions are becoming more and more prevalent already at the state level. And that is probably where the battleground will be in upcoming months and years. And that is the reason that I will again be introducing the Women's Health Protection Act, which does away with unconstitutional state laws that restrict abortion care and instead preserves a woman's right to receive safe and legal abortion free of these unnecessary and burdensome regulations. Abortion is a healthcare procedure that should be safe and legal. It is indeed constitutionally protected. And in addition to the stories that we're hearing this morning, there are countless others, and I could spend the rest of the day recounting them. One is Jennifer Peterson from New Hampshire, who was pregnant when she was diagnosed with invasive breast cancer. She had to make a heart-wrenching decision between continuing her pregnancy and saving her own life. Legislation that bans abortion after 20 weeks with no protections for the mother's health would put her health in jeopardy. Christy Zink, a professor at George Washington University, lost a much-wanted pregnancy at 21 weeks. She learned her pregnancy was diagnosed with severe fetal anomaly. If passed, the 20-week abortion ban would prohibit safe, legal abortion care for women in similar situations nationwide. These stories and experiences are real. They are not theoretical or hypothetical arguments. And in the real world, as you have recounted, Senator Jordan, there are impacts on the availability of health care. And I wonder if you could tell us whether you think that the people of Georgia appreciate what the real-life impacts are of these kinds of restrictions.
So, Senator, with respect to that, and one of the reasons why I shared such a personal story, women don't talk about these issues. They don't want to talk about them, and they shouldn't have to talk about them. It is no one's business what they have to deal with every day. But like I said, every one of the women I know has a story. They've lost children, they've wanted children, they've taken care of children, they've birthed children. And it's one of those things that when we see legislators who really have no idea what that experience is like to try to legislate, you know, it's dumbfounding. And I think with respect to Georgia, which is traditionally a Republican state, I think that Republican women are outraged at some of this stuff because they know that at the end of the day, no woman takes any of these decisions lightly. You don't walk into a doctor's office, you know, wanting to get a horrible diagnosis. So it's one of those things where I wish they would just trust us to make the right decision with respect to our own lives and our own bodies and our children.
Thank you. Thanks, Mr. Chairman.
Thank you all. Thank you. I don't believe we have anyone else. Thank you, Senator Feinstein, very much to all who participated. It was a very informative panel. Thank you all for sharing your point of view with the committee, and I appreciate it very much. We'll hold the record open for comment for the appropriate period of time. Senator Grassley has a statement he'd like to put in the record. We'll do so without objection and mark him as present for the hearing. Thank you all. The hearing is adjourned.